Just a couple of brief words before we begin. Please take some time to fill out the evaluation that you'll find in your binders. They're helpful to us in developing future programs. Second, there's going to be lots of opportunity for you to ask questions. When you do, we don't have a mic available on the floor, so please speak up clearly so everybody can hear. Our chairs are going to repeat your questions to make sure that everyone hears, and that way everyone can benefit from both the question and the answer. There's a couple of papers that are still to be delivered for the binders, so if you think you're not going to be here tomorrow, please drop off your business card with our reception desk, and they'll make sure the materials find their way to you. And finally, I'd like to introduce our hardworking chairs for today's program. Barry Kuretzky and Howard Levitt put a lot of time and energy to bring you this program, and I'd like to thank them for their contribution, as well as our faculty who put a lot of hard work into it. Barry Kuretzky is a senior partner at the law firm of Kuretzky Vassos, and he specialized in the area of employment law since he was called to the bar in 1978. And Howard Levitt is a partner with Lang Michener here in Toronto. He's presently counsel to the firm and a member of the Employment and Labor Law Group, and he practices exclusively in that area. Please help me welcome Barry and Howard.
Well, welcome, and thank you for attending. We've tried to create a format that you'll learn everything one needs to know, and there frankly exists, for at least up to today's point, in employment law from the moment of hiring to the time of termination and beyond. And we've tried not only to cover that, but to be a little leading edge in some of the issues we're going to be developing. We thought, what questions do we want to know the answer to? And some of the ones include, how do you present yourselves in a case to a judge? Is there any room left for the Kronk Doctrine? To what extent is arbitration law merging into common law? Is there a right to any form of natural justice when employees fired? Are there any circumstances left where courts are going to award aggravated or punitive damages in the absence of an independent tort? What factual impact arises from the expressions of the Supreme Court of Canada as the importance of work and the devastating impact of dismissal? Are there different standards on employers, and for example, depending upon the size or sophistication of the company? And what's the legal impact of representations made not before but during the employment relationship? And these are the kinds of relatively leading edge issues that are going to be canvassed by our various speakers. So I trust you'll find it elucidating.
Howard's always elucidating. I also want to extend a warm welcome to you for attending the first annual Employment Law Forum. Howard and I, with the assistance of Beverly Spencer and Andrea Camazuli of the Law Society, have hopefully put together an informative and exciting 2 days to cover the host of topics. As you all know, employment law is a very complex area. It's a very human area. It recalls, you have to have a lot of sensitivity to practice in this area. You have to be a bit psychologist, you have to listen to your client's issues, and hopefully during the next 2 days you'll not only glean a great deal of law, but a great deal of strategy and sensitivity to how to process and how to positively deal with an employment law claim from all aspects. It's my privilege at this time to introduce Mr. Justice Gans as our keynote speaker. Mr. Justice Gans was an instrumental player in employment law since the area of law really took hold on the legal landscape in the late 1970s. Art was co-editor of Canadian Cases on Employment Law and a lecturer at numerous Law Society and Canadian Bar conferences, providing not only sound legal reasoning, but the practical aspects of how to put forth a claim. I have great personal respect for Art's abilities when he was in the opposition. And you were never quite sure how Art was going to take apart your client, but rest assured he took apart your client. I was particularly pleased as such when he was called to the bench in 1997. Many of you are not aware, especially if you've appeared before him, that Art has a softer side. He has a wonderful wife who's plugged this, and 2 great kids, one whose last is off in Africa. And also, he's an accomplished photographer. His address this morning, I'm sure, will provide you with a good legal overview, but also he'll probably have a little bit of humor, as Art's noted for. Art, I'd like to welcome you to the podium.
Thanks, Barry. Can I have a glass of water? Sure. He's now going to perform a most necessary function and hand me a glass of water. I'm not sure anybody really wants to sit at the back of this room, other than Hugh Dyer, I see. But if any of you wishes to move up, I'm sure that the chairs wouldn't object too strenuously to it. I'm not going to discuss anything leading edge, particularly since I don't know anything leading edge. I don't read the ORs, and I for sure don't read the Canadian cases on employment law. I wait until I'm presented with them. So if you're expecting something leading edge or erudite in respect to matters of law, you ain't gonna get it from me. I got a call unexpectedly about a month ago from one of the functionaries at the Law Society, at which I was summarily advised I was going to be the keynote speaker today. Obviously, from the numbers in this room, it was not one hell of a drawing card for anybody to see me here today. But imagine my surprise that I was going to be the keynote speaker and that I was going to participate in this forum in a matter other than just in a judge's panel. I was going to have to prepare, something with which I am not used. I must say I was a little put out with Kuretzky for A, calling me Art throughout his introduction, and B, for putting me in this rather invidious position. Such would of necessity oblige me to prepare some appropriate comments that might require some form of judicial circumspection, a quality for which I'm not generally known. I quickly decided to resort to one of the much overlooked litigation propositions, by which one should avoid at all costs anger and uncontrolled blood pressure increments. Instead, I determined to focus my attention and energies on crafting a get-even policy for Kuretzky. Consequently, as an introduction to my speech, I've decided to focus my remarks, albeit but briefly, and there will be a test, Hugh Dyer, albeit but briefly, on a much maligned area of the law, the Chancery Amendment Act of 1858. Otherwise known as Lord Cairns Act. Now, does anybody know what Lord Cairns Act is? Could you raise your hands? Now, come on. Surely somebody knows what Cairns Act is. Well, let me pose the question another way. Does anybody care? Could you raise your hands on that one? Again, the same response, not surprised. Well, just to refresh your memory from Civ Pro 1, the act was, in fact, a very important piece of legislation, since it was the precursor to the Ontario Judicature Act of 1881. Again, who cares? But it effectively completed the merger between courts of law and courts of equity. And that, to me, is really important. Now, before any of you starts for the door, and I haven't seen that as yet, or grabs for the Globe and Mail or the National Post, I can assure you that what I intend to speak on, but briefly at this moment in time, will not necessarily cause your eyes to glaze over. What I intend to tell you in very simple terms is how the merger of law and equity was applied most recently without so much as saying it was applied. The case in point is the oft-cited recent decision of Mr. Justice Iacobucci and Wallace. What a surprise. First, there's no doubt that a read of the majority decision and a read of the dissent of the now Chief Justice is enough to make you really rethink whether or not you want to remain in law, or whether you really want to consider becoming a master or mistress of the universe, a stockbroker, or indeed a personal trainer. I'd opt for the latter. Simply put, the case underscores the very essence of the combined effect of law and equity. Not so much for the concepts of equity, first expressed in arcane fashion in the earliest courts of chancery, but for the notion of equity, and I underscore that word, as that concept is better known by those of us not burdened by an LLB, namely, doing what's right under all the circumstances. If you doubt what I say, I'd ask you to think about giving me, or being able to give me, in 10 words or less, the legal ratio of the majority decision in that case. I'm not sure I can give it to you. What then is the lesson to be learned from Wallace? Well, know who the author of the majority decision was. He coached me soccer in law school. He was the nicest guy you'd ever want to meet. Now, if you think about that, then you understand what Wallace is all about. You can forget about the contract principles and independent actionable wrongs when it comes to firing somebody. Simply put, if you fire someone, or worse, you advise your client on the firing in what can reasonably be perceived as a high-handed and harsh fashion, even if not capable of causing mental distress or the required added condemnation of the court through some measure of punitive damages, know that your client, the employer, is going to be hammered by the trial judge. That's what you draw from Wallace. The period of notice that will be awarded in your case will be on the high end of reasonable, sufficient to make the judgment unassailable, even if I or one of my colleagues does not earmark the amount as a Wallace-type award. The bottom line is that the manner of the discharge better be reasonable, if not humanistic, having regard to the simple fact that the results of the termination can be potentially devastating. Now, I said that same nonsense to my clients in the 70s and in the 80s. So that which we read in a 55-page judgment in Wallace says nothing more than these guys said to their clients, and I dare say that most of you have said to your clients. This, then, is the amalgam of law and equity, where the courts fashion a remedy that just can't be fit into some legal pigeonhole. It really adds nothing to the law of wrongful dismissal. It underscores the fact that if you're going to fire someone, even if it's for cause, make sure you don't add insult to injury. It will only come back to haunt you. Now let's talk about the process of litigation, about which I think I know a lot. From my perspective, sitting on the bench presently, and more importantly, from my perspective, having dealt with most of the folks here on the panel and those whom you will hear over the next couple days. It's been long since stated that the only person who benefits from litigation, from protracted litigation, is the lawyer. While that aphorism is generally correct, I can tell you that in the area of wrongful dismissal, the lawyer who does best is the lawyer who settles early and settles often. Right here, right here. They make more money than God, and they do it because they settle early and they settle often. Let me take Kuretzky as a case in point. The last time he had his gown on was when he was called to the bar. He can't remember when he did his last wrongful trial, which I dare say was his first. You don't make money in wrongful engaging in protracted litigation unless, and I underscore this, the dismissed employee was a big-ticket executive. I guarantee you that on an hourly rated basis, you'll score more if you settle early, even for the big-ticket employee, than you would after trial and after an appeal. Now, leaving aside my natural cynicism for the moment, you owe it to the dismissed employee, for one, to settle the matter as soon as is humanly possible. You've all heard this before. Dismissal, together with divorce and death, is well documented as a huge life stressor and can lead one to, and dismissal for one can lead to the other too. So how do you guarantee a quick resolution? Well, I make fun of Kuretzky, but underscoring how he achieves settlement quickly is the fact that he's easy to deal with. Strange concept. When you represent a dismissed employee, don't send the employer stupid letters. Don't send stupid letters asking for all manner of damages which bear no relation to the facts. Don't ask for damages for mental distress when such aren't appropriate. On a more fundamental basis, don't ask for 24 months when the realistic cap is between 10 and 12. Be straight up about your demands and fashion the request as an invitation to negotiate as opposed to litigate. I can tell you, when I receive letters across my desk from him, which ask for the moon, I said, hey, we're into a battle. The heck with them. My expression was a little more artful than the heck with them. On the flip side, it's not easy and it's not always in the company's interest to drag out the case interminably. No doubt there are advantages to ragging the puck from time to time, thereby forcing the plaintiff to jump through hoops during the course of litigation. Some plaintiffs will tire of litigation and after a while may be more inclined to settle for something less than they might have done earlier on in the piece. But unless you're trying to impress your client as to how much of a tough guy you really are, remember, most employers want to get on with the business at hand. They're not in the business to litigate. They're in the business to make money in whatever enterprise they're conducting. And generally, they have no stomach for the fight. Most often, after flared tempers subside, the boss is anxious to rid the company of the problem just as much as the plaintiff is in settling. Particularly, and think about this, particularly if the settlement payment can be spread out into the next fiscal year. A simple concept, but an important concept. The boss doesn't want to reflect the payment of that amount in this year's earnings. Why? Because in large corporations, their bonuses are predicated upon the bottom line. And if they can spread it out into the next year, it's great and it's important. And you'll be able to affect settlement that much easier, much more easily. Thank you, Art. Okay. If you think this is a misguided approach, think about the counsel who do a lot of wrongful dismissal, and you may want to make inquiries of these counsel over the next 2 days. Think about who goes to court. I'm sure all of you have heard about Randy Eklund. I don't think that guy's ever been to court. And I could list a whole raft of folks who've never walked through the courthouse door. That fact alone, in my view, speaks volumes. Now, there are certain cases that do warrant a full court press. There are certain cases where there are interest issues that transcend the beef between the parties. And those cases may have to be litigated. But I can assure you, those cases are few and far between. The object lesson in all of this is to pick and choose the spots on which you want to wage all-out war. Then go to battle, and go to battle with one view in mind, to win. Now, there's one small point when you act for an employer. Those who do strictly labor law, as opposed to employment-related law, those who have to deal with collective bargaining folks, have known this rule since day one. I saw that when I was at Miller Thompson. If you act for an employer, think about making the trip to the factory or office of the employer. Don't deal with this downtown in your office. Get in your car, get out to the client's offices, and see the operation firsthand. You never know what other people are out there that might provide some interesting information. You also never know what documents may repose out there that the client wouldn't send downtown or send to your office. More importantly, you see where that dismissed employee worked. You have a sense of the geography. You have a sense of the environment. You understand when you're doing a discovery and the employee tells you about a situation, you can visualize in your mind's eye that about which the employee is talking. You know if the employee is stringing you along. You'd never know that sitting in the Sun Life Tower. You'd have no clue whether or not your chain's being yanked under any circumstance. Now, there's a side benefit to all of this. And labor lawyers have known this all along. Clients love it when the lawyer comes for visits. They don't want to come to your office. They want you to come to their office. And I'm telling you from personal experience, you will endear yourself for life with this particular client. Now let's get back to the deal. To get a good deal, one need not, and listen up on this, one need not be belligerent or heavy-handed or indeed rude. This is a small bar, this employment, wrongful labor law bar. It's a small bar. When I was practicing, when I was a student, which seems like 1,000 years ago, and the old-time labor lawyers for whom I had to work, and it was a management, and Miller Thompson is, as most of you know, a management-oriented firm. It was we and they. It was a we-they approach to life. They hated Ian Scott. They hated Steve Gouge. They hated Chris Paliare. These are the old-timers. And I thought to myself, what kind of nonsense is that? How could you hate these guys? They're just doing their job. I moved into the litigation section, and my boss then didn't have a we-they approach to life. He had a we-they approach to the litigation, but he taught me early on in the piece that a lot more was accomplished not pissing off the other side, making sure that you didn't burn your bridges, making sure that what you said today was going to stand you in good stead tomorrow. Now remember, you're going to meet each other coming around the corner more often than not if you continue in this relatively small bar. Remember that what you say today will come back to haunt you tomorrow or will stand you in good stead tomorrow. Remember that if you don't throw someone a stiff today, they'll appreciate it tomorrow. Remember, and this is a lesson I learned from Randy Eklund, when you're generous on costs with your opponent on a settlement today, it will come back in spades tomorrow. Something I was absolutely astonished to hear. He telling me the deals that he and Kuretzky would cook up on costs. Anyway, I'm telling you that it's easier to approach life in that fashion than any other. Now, there's one other aspect of the practice that I'm advocating. There's a sign, I don't know if any of you has the misfortune of doing family. I've now made my first foray into family after 4 years. Thankfully, it'll be short-lived. But in any event, there's a sign on Madame Justice Spiegel's door which says, mediate, don't litigate. Now, having expressed that view, and I firmly believe in that view, notwithstanding the fact that I loved to litigate. I loved going into court. I loved cross-examining people. I loved making sure that I got their mouth real dry like mine is right now and that white stuff would come out to the corner. I loved seeing it. It was ecstasy. And the more I saw, the more I thrived on it. Having said that, in those days, I wasn't making big bread. And that was the trade-off to that situation. Now, having dealt with it, it should never be said of you that you're afraid to go into court. Because if you get a reputation of a person who is inclined to settle but not go into court, know that when push comes to shove, I'm going to know, or I did know in practice, that person won't walk through the door in the final analysis. That's a huge advantage. So it may be that you're going to have to try cases from time to time just to make sure that you don't get a reputation as a total pooch. You're going to have to make sure that when you say, okay, I'll see you in court, they'll see you in court. Because what happens then is the case will settle on the courthouse door, at the courthouse door, but it will settle on more advantageous terms for your client. Now, let's talk about moving the case on with dispatch so I can get out of here. If you act for the plaintiff, it's clearly in your interest to move the case on for trial or at least up to the pretrial stage. Consequently, in my view, don't mess around with too many, if any, interlocutory skirmishes. Unless the pleading is positively scandalous, and by that I mean as that term is commonly understood as opposed to the term in Rule 21, whatever. I mean, let's talk about it being absolutely defamatory of your client that you don't want in the general press. Unless that pleading's positively scandalous, forget about it. Move on to the next stage. In a wrongful case, the pleading is truly overrated, in my view. While pleadings are read by the trial judge in preparation of the matter for trial, it's the evidence in court that's critical. It's the evidence on the arbitration that's critical. It ain't the pleading. You'll amend the pleading. I'll let you amend the pleading to conform with the evidence ultimately. Don't worry about that. Now, having said that, that which looms large at the start of the case, oh, look at this pleading, it's just pathetic, I got to move against it. I can tell you, ultimately, it's of no moment. Therefore, keep the motions at the beginning to a minimum. You can always get needed particulars on discovery. So long as you have a full and frank discovery, you don't have to mess about pinning somebody down on their pleadings. The judge is going to let them move around that pleading in any event. The unfortunate side effect of this, from my perspective, is the pleadings I see are pathetic. They break every rule of pleading. They are poorly drafted, poorly thought out, and become boilerplate. I'm waiting to see in a wrongful file that he failed to keep a proper lookout, that he was driving while under the influence. I'm waiting for an amalgam of that fender-bender pleading with the wrongful pleading. He did fender-bender stuff in the early stages. I'm not surprised if we're not going to get a merger of those two macros one day on his statements of claim. But leave my water. They are pathetic, the pleadings. Now, the only motion throughout the course of litigation that you might consider making, now think about this. The only motion you might consider bringing is a motion for summary judgment. Ooh, he says, she says, what about Kilpatrick and Peterborough Civic Hospital? A loser for John Sproat, remind him when you see him, he's coming here to talk, and a winner for Chris Paliare. Remind him when you see him, you'll endear yourself to him. I'm not unmindful of the decision of Mr. Justice Bournes in Kilpatrick. I'm also mindful of a decision of one of my colleagues, Mr. Justice Jennings, in King and Giffords Holdings. And this is the only case I'll give you the cite for. 1999, 46 OR 3rd at page 17. That is an important case because I can tell you if your opponent is in agreement that this case calls for a motion for summary judgment on the amount of notice, then take advantage of that particular request. Fashion the material that goes before the judge at first instance in a manner that he or she can readily understand and where the facts will not be in dispute. And I can tell you that I, for one, will entertain a motion for summary judgment to fix the period of notice if there are no material facts in dispute. There are others of my colleagues that will do so, notwithstanding Kilpatrick and Peterborough Civic Hospital. Think about it. I think it's still an important tool to be used. I'm getting out of here soon. I just got a couple other things I want to cover off. Discoveries. In my view, discoveries are the most important tool for today's litigators. The most important tool, because none of you gets to court. Not one of you will be doing trials in the next 5 years. So the discovery becomes critical. Treat the discovery as the real thing. Prepare your client as if he or she is going to testify at trial. Prepare your discovery of the other side as if it's the real thing. And be prepared to cross your opponent. This means that you have to know your case from top to bottom, early on in the piece, not at trial. Don't treat the discovery as just trying to find out what your opponent's case is all about. Treat your discovery as a way to pin that person down and also to get in that person's face so that that person knows who you are and what to expect if this matter regrettably goes all the way. And you can only do that if you know the facts, if you know the issues, and if you know the documents. And if you come to discovery and you don't spend the time and you treat it in a perfunctory fashion and you're not prepared, you're wasting your time. And I can tell you, it's a waste of time for me when somebody tries to read in aspects of the discovery. Do your discovery in an organized and logical fashion. Some people do it by topic areas. I was too stupid to do it by topic areas. I had to do it chronologically. And the advantage to doing something in a chronological fashion means that you can readily find it when you're at trial and you're hustling about trying to find something upon which you want to cross-examine the individual. Again, in discovery, there's no place for belligerence or rudeness. The knowledge is the power, not a show of bravado. When you finish the discovery, think about whether it's necessary to bring any motions for unanswered questions. I, for one, never did that. It was a total waste of time. But I wrote the other side a letter and said, you have refused A, B, and C. You have told me that it's because of X, Y, and Z. It's with that fact upon which, that fact is something about which I take issue. Please be advised that you will not at trial be permitted to lead any evidence in respect to that fact, in respect to those issues, unless I receive well in advance of trial the information upon which such and such a position is predicated. Rest assured that that's an important letter to send. Don't engage in a whizzing contest with the person on the discovery. Don't get your blood pressure up. It's not worth it. And for heaven's sake, don't bring a motion. It's a waste of time. It's a waste of energy. Now, there are times when people do refuse on discovery to permit the client to answer questions. From my perspective, I always let my client never use the word always. In most instances, I allowed my client to answer questions. I wanted to see how the client was going to fare under the storm, under the barrage. I wanted to understand how they would make out in the final analysis. But there were some instances where I hadn't prepared the client. And all of a sudden, out of left field, some huge issue arises. And I think, maybe I better intercede here on this discovery. I would intercede, but I wouldn't leave it at that. Politely, firmly, all that stuff. I'd intercede, and then I'd get the straight goods from my client by shaking him or her down after the discovery to find out why I hadn't been alerted to this particular fact. And then I would answer the question, lest somebody turn that little system upon me, and where I would ultimately be prevented from relying upon the evidence ultimately at trial. So think about that. Again, there's no reason to be a jerk on the discovery. The job as a litigator is tough enough. You don't have to be a total, can you want to say that word for me? You don't have to be a total idiot about it. Firm but polite is the order of the day, unless you're fighting fire with fire. The life of a litigator, in my view, is too short, and it's easier to go through in a reasonable fashion than any other. Last topic. Pre-trials. Do me a favor, don't come to the pre-trial unless you're prepared. Don't waste my time. When you come to the pre-trial, prepare a complete brief. That means your pre-trial statement and not some cursory thing or perfunctory thing where you repeat a couple of the allegations contained in your statement of claim. I don't want to hear that. I want the full story. And if there are documents that are important to the pre-trial, append them as exhibits. And don't send a junior or don't send somebody not familiar with the file. I don't want that. You're wasting my time. And you're wasting the time of some of my colleagues who believe that we, judges, have an important role to play. Notwithstanding what the Chief Justice of Ontario has said in terms of the M word, meaning to mediate, there are several of us who come to pretrials with that view in mind. There ain't a pretrial that I can't settle. That's the view that I bring to bear when I come to the pretrial. But you have to help me. You gotta give me the full scope. You can't just give me a half-ass presentation. Now, also remember that the pretrial memo is an important tool in the advocacy arsenal. Having said that, make sure you use it to its fullest advantage. Make sure that by the time I finished reading the material in preparation of the pretrial, I'm on your side. And that I come in and I start to muscle your opponent. I may muscle you as well because I want to get a deal done. And I know that you're going to have to ratchet down your views and the desires of your client to some extent. But use it effectively and use it as an important tool. There's a lot more that I want to say, but I'm not going to. You should see what we got paid for this gig. So I'm finished. Thank you very much.
You are excused, Mr. Justice Gans. Thanks very much, Mr. Justice Gans, or commonly Art, for his very entertaining but very practical advice on how to
Anybody have a quick question, then I'll get out of it. And you get this affidavit, and you can get the document. Now, I'm not trying to be dismissive of the proposition. Labor lawyers have been faced with this thing for 1,000,000 years. Those guys have never had discovery. In the old days, Hugh, you can tell me, I don't think they had production of documents. And you know what? They were able to do it effectively since the beginning of time. So it's not a big deal. It's never been a big deal for the labor lawyer who's been fighting these battles, and they do arbitrations one after another. Do you follow what I'm saying? That's probably not being responsive to your question, for which I apologize. But it's not an insurmountable task. Now, if the simplified rules, as Peter tells me, mandate the preparation of an affidavit of documents, and you get the documents in advance, it's Thankfully, I think I've done only one simplified rules trial in the 3.5 years. But that should be enough. When you sit down and you read the documents and you prepare, I think that's a heck of a lot more than folks did get when I was involved in the employment, that is the collective bargaining end of labor relations. Huey, help me out on that. What kind of documents here? And that shouldn't handicap you. This is an expeditious process, the simplified rules procedure. And it should be expeditious. And you should, when I'm talking about discovery, and the discoveries I'm talking about are ones that involve somewhat more complicated cases. But no, a wrongful dismissal area, notwithstanding what these guys represent to the general public, it's not rocket science. It's the simplest of all law, from my humble experience. Otherwise, how could I have done it for all those years? Any other questions? Thanks.
Once again, thanks, Mr. Justice Gans. Our next speaker is Norman Grosman, and he's a graduate of Windsor. Norm's also senior partner with the firm of Grosman & Gale, a constant opponent of mine. We've tussled a few times, and it's always a good and positive experience. He's the author of Federal Employment Law in Canada and a Practical Guide to the Law of Hiring in Ontario, a contributor to Canadian Human Resources Reporter, the Law Advocates Quarterly, Lawyers Weekly, Employment Letter, and Employment Bulletin. Would you please give Norm your full attention?
Thanks, Barry and Howard, for inviting me. It's always a challenge to follow the comments of the Honorable Mr. Justice Gans. Allow me just a quick moment to pick up on something he said about kind of congeniality at the bar, because I had one experience with Art Gans when he was practicing. I was acting for a plaintiff, he was acting for the company. It was a wrongful dismissal case. We went to the pretrial conference, and we were both miserably unhappy with who we were going to be appearing in front of, because we weren't confident that we were going to have a useful pretrial experience. I'll skip the name of the individual who's no longer on the bench. But we agreed in advance that we would go up to his chambers and we would come up with a story that we had cooked up about why we couldn't possibly proceed with the pretrial in that particular instance. And I was grateful to Justice Gans for cooperating with me, because I was the one who was more concerned that we weren't going to make progress. Anyway, we go up to chambers, and the judge who is hearing the matter, we explain to him that we can't possibly go ahead for certain reasons, and he expresses great disappointment because he's prepared, he's read the material, and he says, well, let me at least give you the benefit of my comments, and then we'll decide whether or not the pretrial is going to go ahead. He turns to me immediately and says, Mr. Grosman, your client's an asshole. And to Art Gans' credit, when he had an opportunity to put me 6 feet under, he stuck with the game plan. He helped me with the fancy footwork to get out of the room, and I never forgot it. And so I certainly endorse his comments about the importance of working with counsel. I'm speaking to you today briefly about constructive dismissal. It's difficult to speak briefly about constructive dismissal, but one of the things Barry said in his opening comments struck a chord with me, and that's kind of about the interface of human nature and employment law. I don't think there's an area of employment law which demonstrates that interface more often and more substantively than the law of constructive dismissal. One of the most paradoxical things about employment relationships is that change is a constant. Organizations are constantly changing, they're evolving, they're reorganizing, they're growing, they're shrinking, they're reinventing themselves, and as a natural result of that process, individuals are faced with all kinds of changes in their jobs, some significant, some relatively insignificant. In my practice, I can tell you that I'm seeing more and more people who are affected by change, whether it manifests itself in terms of changes to their responsibilities and duties, their reporting relationships, their compensation, their authority, or their status. And as a result of those changes, they come and see me and they tell me they're unhappy. And in fact, many of them have already decided by the time they come and see me that they want out. Frankly, some of them have rights from a legal perspective. Some of them don't have much in the way of rights. Now, they can always resign, but that's not really what they have in mind. That's half of what they want, is to get out as a result of the change which they perceive has affected them. What they really want is to get out and get a package. Some of them also come equipped with a little bit of knowledge about the area of constructive dismissal, and it truly promotes the adage that a little bit of knowledge can be a dangerous thing, because they come and they believe, I've got a case for constructive dismissal, how soon can I leave and how big a package can you get me? I think that when they walk into your office, you have a critical role as their counsel, and that is to take hold of the situation, bring them back to the planet Earth, and help them assess the risk, the magnitude of the risk of their particular situation. If you're dealing with somebody who's got a lot of years of service and is at a vulnerable age, that risk is substantial, and they're depending on you to help them wind their way through a maze of constructive dismissal, or to decide that this is not at all the best route for them because the risk is just too high for them to absorb. It's obviously trite to say that employment relationships are based in contract. The notion of constructive dismissal, which is really just a subspecies of a breach of contract action, essentially stands for the proposition that neither party to the employment contract can come along in the middle of the relationship and of its own volition, that is to say without the consent, agreement, or acquiescence over time on the part of the other party, significantly or fundamentally change existing terms. Or, recent case law has really established, by its behavior and actions, act in a manner so as to repudiate the existing contract. What I often tell clients is I bring it back to lay terms and I say, imagine you came into your place of work on Monday and you said to them, you know what, I've been thinking about this over the weekend. This working 5 days a week really doesn't work all that well for me. So I've decided that I'm going to start working 3 days a week as of today, and this is going to work out really well for me. I'm going to enjoy myself. Of course, I expect you're going to pay me the same compensation. You might expect that the employer in those circumstances will say, hey, time out, wait just a second here. You can't come along in the middle of our contractual relationship and unilaterally and fundamentally change the terms. So the law says in reverse. The employer may not come along in the middle of the relationship and unilaterally and fundamentally change the terms of the legal relationship. There's a recent Court of Appeal decision in Ontario, which I want to just use as sort of the legal example of that lay proposition. And that's a decision in Shaw, S-H-A-H, and Xerox Canada. And it will be my one case that I'll give you the cite for. It's in 49 CCEL at page 166. And it's a case dead on the law of constructive dismissal. And the problem in that case was the appellant said that at trial, the plaintiff had not proven that there was a significant or fundamental change to an existing term of his contract of employment. In other words, he hadn't come and said, oh, I got demoted from supervisor to clerk, or he didn't say they changed my compensation from $100,000 a year to $50,000. Instead, the complaint was that the employer had, in perhaps a more subtle fashion, created an intolerable work environment without changing any specific term of employment. And the Ontario Court of Appeal said, while it's absolutely true that constructive dismissal, the nuts and bolts of constructive dismissal, revolves around a unilateral change to existing terms and conditions of employment, and that change or changes must be significant or fundamental, it also hammered home the proposition that a constructive dismissal can occur even in circumstances where there has been no significant or fundamental change to a specific term, if the employer has demonstrated an intention by its actions or behavior to repudiate the contract of employment. And it relied on a Manitoba Court of Appeal decision in a case where the employer had unjustifiably criticized the employee, leveled vague and unfounded accusations against the employee, and created what the court concluded was a hostile and embarrassing work environment. And even though in those circumstances, the employee's job hadn't changed, compensation hadn't changed, reporting relationships hadn't changed, the court said that's enough in order to create a repudiation of the contract of employment and therefore a constructive dismissal. You can imagine, however, that when you're dealing with that second branch of constructive dismissal, if I can call it that the evidentiary burden is a little trickier because your client will not be getting up and saying, well, yesterday I was a supervisor, today I'm a clerk, yesterday I earned $100,000, today I'm earning $50,000, but rather the evidence will just be a little more subtle and sophisticated in terms of explaining to the trial judge how the environment became hostile, aggressive, and intolerable, such that your client didn't have to put up with that, and in effect the employer had repudiated the contract of employment. It's critical to remember in any constructive dismissal case that the onus is on the individual. The onus is on the former employee, and that makes a huge difference in terms of how you approach the case. Sometimes, in my experience, where the risk is high of the employee screaming the words constructive dismissal and walking out, sometimes I find it's better for the employee to consider a strategy of staying put and agitating to create their own dismissal. But in terms of assessing that risk, I think you have to look at the position that the employer is likely to take, most likely to take, in the event that you, on behalf of your client, come forward and assert a constructive dismissal. And the Mifsud and McMillan-Bathurst case, which is another Ontario Court of Appeal decision, really, if you break it down, says that you can expect that an employer, when you allege constructive dismissal, is going to say two, maybe three things. The first knee-jerk reaction, the first layer of defense is going to be, no, we don't think so. We don't agree with your factual analysis, and we don't think your client was, in fact, constructively dismissed. As far as we're concerned, your client quit. Right away, they've manufactured an atmosphere for the purpose of negotiation, if for no other purpose, where they're going to be looking for a deep dish discount on what your client might otherwise have been entitled to. They have some arguments that it isn't a constructive dismissal and that your client in fact quit, and if that's the case, your client's entitled to nothing. On the other hand, you have your arguments that it is a constructive dismissal, in which case, if you're right, your client's entitled to the whole enchilada, whatever that may turn out to be. Remember that constructive dismissal and the factual analysis of a constructive dismissal case, so the courts tell us, is meant to be an objective test. However, perceptions of colleagues around your client are an element which a trial judge will accept in terms of developing what the objective events were. But the employer's motives, often put forward by employer's counsel as an important aspect of the case. In other words, we did it for legitimate reasons, so we can't be held accountable, is but one factor that a court will take into account in determining whether or not there's been a constructive dismissal. The second line of defense, which appears infrequently but which should not be lost upon you, also comes from the Mifsud decision. It's one that I have a lot of trouble with. And in Mifsud, the Court of Appeal said that if your client had been promoted from one position to a more senior position, and again on an objective basis had not been able to meet the fair and reasonable standards of the new and promoted position, the employer has the right to put the employee back to the former position without having committed a constructive dismissal. There is this implied term that if the person is not performing at the more senior level, the employer has a right and ability to move them back to the more junior level without committing a constructive dismissal. The wild thing about it was in the Mifsud case, Mr. Mifsud had been promoted 9 years earlier to the position of superintendent, and yet the Court of Appeal concluded that there was this fictional probationary period, and I can't really tell you how long it lasts. Apparently it lasts 9 years, maybe it lasts more, maybe it lasts a generation, I don't know. But poor Mr. Mifsud had his claim for constructive dismissal shot down because the employer was able to put forward objective evidence that he was not performing at a satisfactory level in the promoted or higher position. The final level of defense, and one which you will see again as a knee-jerk reaction from the employer, is that your client failed to mitigate his or her damages by taking the altered, changed, new, modified job as a way of mitigating his or her damages. In the Mifsud decision, the Ontario Court of Appeal said, where the salary offered is the same, where the working conditions are not substantially different or the work demeaning, and where the personal relationships involved are not acrimonious, it is reasonable to expect the employee to accept the position offered in mitigation of damages. So it's not enough to simply assess whether or not the events which have transpired and the changes that your client originally came in to speak to you about constitute a constructive dismissal. You have to go one step further and ask your client and then ask yourself, does this person have a legal duty to mitigate their damages by accepting the new job while they look for employment elsewhere? And that's a tricky proposition, but it's one that you can't lose sight of. Finally, I just want to comment on employers that provide considerable advance notice to employees that a change in their circumstances or employment relationship is going to occur. It's certainly my belief, and there's case law to support it, that if the employer does provide reasonable advance notice of a change or changes to the employment relationship, no matter how fundamental, it does not constitute a constructive dismissal. It's as if they terminated the existing contract on reasonable notice and therefore did not breach it and put a new contract of employment or offered a new contract of employment in its place, which your client can either accept or reject. One last comment, and maybe I'll have time for a question or two. Tread carefully in the area of constructive dismissal, lest you pick up your foot and find something on it that you were not expecting and that you're not really sure how to clean up. I hope those comments are helpful. And I'm pretty much out of time, but if you have a question or two, maybe I can grab them. Great, I've solved all the problems of the universe but one.
You just mentioned about notice. The notice to approximate, the notice that you might give that employee notice to termination.
Yes, the question is, in terms of notice, if the employer is giving advance notice of a change in the terms or conditions, would that notice approximate the kind of notice that you would have to give that employee in the event of termination? And the answer is it should not approximate, it should be the same.
On the same lines, what if you change the limits of responsibility effective 2 weeks from the notice, but guarantee the remuneration for the reasonable notice?
Peter's question is, what if you change the duties or responsibilities with 2 weeks' notice, but say that you're going to guarantee the compensation indefinitely? Again, that goes, I think, to the question of whether or not the person has a duty to mitigate, and you've got to look at those 3 criteria from Mifsud. Certainly, in Peter's example, you've hit the first criteria, and that is the compensation offered is the same. But you may, when somebody has been demoted, particularly if it's a kind of demeaning or humiliating or embarrassing scenario, you may either be able to make out the case that they ought not to be expected to mitigate in a situation like that because it will demean them, or perhaps you may be able to access the line of reasoning that it's a repudiation on the part of the employer in the sense that it's creating a hostile, aggressive, intolerable work environment, because there may be some rationale which the employer is giving where they're criticizing performance and it's really not warranted, or they're setting standards of performance which are really not realistic, and that may give you access to the second branch, as I call it, of constructive dismissal, and that is the Shaw and Xerox line of reasoning, which by the way, takes off from the Farber case from the Supreme Court of Canada and says that if the employer is creating that kind of an environment, it is a repudiation of the intention to have an employment relationship. And Justice Gans also mentioned the line of cases where the Supreme Court continues to talk about the vulnerable nature of employees in the employment relationship, the unique nature of the employment relationship. Those cases are going to help you in any constructive dismissal scenario as well. Okay?
Does the employer have the right to realign sales territories or reorganize their organization without bringing on a constructive dismissal case if it doesn't reduce salaries or something?
Well, the answer is sort of. The motives of the employer are one factor that will be considered, but if the net effect on an employee is to alter in a significant way the terms of their contract of employment, no matter how legitimate the interests of the employer, it won't cut it.
Their salaries or their commission's not going to be reduced.
Well, then we get back effectively to the question that Peter asked, and that is, does the individual have, it may be a constructive dismissal, but does the individual in those circumstances have a duty to mitigate? Right, thank you very much.
Thanks very much, Norm. I was pleased to lead off with that topic because it is the most difficult topic, because you really put an employee in a difficult position. And I always say, when they come into my office, I always say, look, this is the employee's dilemma. Do you have humble pie, take your money, and move on to another job, which in a sense is the Mifsud decision. I thought that Court of Appeal decision when it came out was a terrible decision. I still think it's a terrible decision, because per Mr. Mifsud, having succeeded at the trial level, lost at the Court of Appeal, and you can imagine, as Mr. Justice Gans would have said, the costs that were just had to be enormous for him on the personal side, never mind what he paid out to his lawyers.
And the Shaw case plus the Mifsud case introduced tremendous subjectivity in the trial judge, and you really aren't going to know what the result is until you get to trial. It's going to be the particular views of that trial judge as to whether something's objectively humiliating in the Mifsud case, or whether or not something's an intolerable work environment or conforms with that particular judge's notion of workplace rights or employees' reasonable sensibilities. And that's the real change in constructive dismissal law, which makes it very, very difficult to confidently advise any employee to proceed with a case.
It's my pleasure now to introduce Peter Israel. Peter and I have been litigating. I see he was called to the bar in 1978, the same year that I was called to the bar, and we've been litigating probably since that point in time. Our best piece of litigation was one that occurred in the early 80s, and Peter, and this is exactly what Mr. Justice Gans had said, Peter took over a file from an insurance counsel. At that time, many of these lawsuits were insured, and you'd get fender bender lawyers working through these files, and it was a dog's breakfast. They had driven me crazy, but they had forgot to look at one important thing, which Peter picked up quickly. I had set the action down in Newmarket, which meant the trial was going to happen in a few months. And so we moved to a quick resolution. In any event, Peter is most distinguished counsel, having appeared at numerous conferences, has a host of clients from the corporate side and the individual side, which I've always found in litigating with Peter that there's sound advice, whatever side of the table he's acting on. Peter?
Thank you, Barry. I never had a pleasant experience with Artie Gans when he was in practice. My topic is restrictive covenants, so we're going to sort of do a little sideways move because while it is very much in the context of employment, it really is an area of law that has developed since the 1700s in its own direction. And forgive me if I'm going to get sort of a little basic. I just want to make sure that we are all on the same page when it comes to analyze the case, which is at tab 2, by the way, because what I'm really doing is providing you with a case comment on a decision of the Ontario Court of Appeal, which was decided in September, on September 21st of this year. The good news is that one of the justices sitting on the appeal was Stephen Gouge, who is going to be here during this program. And I think if you care, there are some very good questions that you can pose to Gouge. But let's go back to restrictive
It's a good reason to
covenant.
stay to the end of the show.
As I'm sure all of you are aware, most employment agreements in this jurisdiction of ours have concepts of restriction in them. The concepts usually fall into one of 3 categories. One is a non-competition agreement, which purports to actually prohibit an individual from competing with the business of the employer after departure, whether on his own or by joining a competitor. Concepts of non-solicitation or non-dealing, non-solicitation being a purported requirement by the employer of the departing employee not to solicit the customer base or the client base of the ex-employer. Non-deal, which is not quite as common, but is somewhat more onerous in the sense that not only is the ex-employee required not to solicit, but even if that ex-customer comes to him or her, they are obliged to not deal with that individual for a certain period of time. And the last one is confidentiality clauses, where the employer very rightly protects its trade secrets or confidential information, and we'll touch a little bit on that, because what most people believe to be confidential information, the courts do not consider to be so. The reason all employment agreements have these concepts within them is historical, because in the absence of that kind of agreement, it is very clear in law that an employee, other than potentially a fiduciary employee, and that's a total other side issue which will be covered during the course of the next 2 days, but an employee in the absence of that kind of agreement has the absolute right to leave his employment and compete directly and immediately with his previous employer, so long as he or she doesn't take financial information, confidential information, client lists in a hard copy form. There's lots of jurisprudence, and I fought a bunch of cases with, I don't know, I'm not sure I understand the difference between taking a customer list, which is prohibited, or sitting down with a telephone book, going back and creating your own list from memory, which is quite all right. But in any event, the reason for the restrictive covenants finding their way into employment agreements is that without them, the employee has a right to compete. Therefore, as soon as you utter the words restrictive covenant in our jurisdiction, going back well into the 1700s, you are immediately causing 2 concepts of public policy to clash against one another. And the 2 public policy concerns are that on the one hand, you have the sanctity of contract. Right? A person who enters into a contract ought to be bound to his or her deal, so long as they do it without being misrepresented, without being defrauded, with all of the usual things that go into formation of contract. But I mean, the issue would be that if a person with independent legal advice, with knowledge of what they are getting into, signs an agreement, they should be held to that agreement. So that's public policy issue 1. Public policy issue number 2 is an individual should not be deprived of earning a livelihood in his or her chosen field of endeavor. And in restrictive covenants, those 2 conflict. So as a result, as early as 1893, in the decision of Maxim Nordenfeld, the courts in England came up with a test which has been adopted and is still the test in Ontario, which is that a restrictive covenant is prima facie void unless the party seeking to uphold it establishes that it is reasonable as between the parties and reasonable with a view to the public interest. Therefore, to determine whether a covenant is reasonable with reference to the interests of the parties, the courts have historically asked a number of questions. Does the employer have a proprietary interest which is entitled to protection? Okay. Secondly, the duration, geographical ambit, and scope of the covenant. Is it for too long a time, too large a geographical jurisdiction, too broad in its scope of what it's trying to protect? And thirdly, is the covenant prohibitive of competition generally, or is it limited to prescribing the solicitation of clients of the employer? I won't refer to my material, which is at tab 2, other than to say that on the second page, in 1983, Mr. Justice Creever outlined 16 points that he stated to be applicable in law in Ontario. I've listed the 16. They are still every one of them, good law. More recently, the courts have added some other statements of public policy. They're not sort of a departure from the test that Creever enunciates, but they bring sort of a more modern kind of feeling to them. So that, for instance, the notion that contracts freely entered into without fraud, duress should be upheld and not destroyed by the courts at will. Recognition that proprietary interests can and should be protected by the law to the extent of permitting a party to achieve this by a covenant which is in restraint. Normie made comments, as did Gans, about another flavor that, from my perspective, and I'm biased and I put my bias on the table, has really colored this whole area, and that is that the historical biases, which I've told you about, are very clear. Right? We don't believe in monopolies. We don't want to restrict people from earning a livelihood in their chosen career. The thing that adds to it, I submit, in an unthought out way, is our Supreme Court of Canada. And whether I think that it's unthought out or thought out, it's the law. And what the Supreme Court of Canada has said very, very clearly in this decade is that it considers employees to be a vulnerable group in society. All right, I'll read you some of the quotes because I think personally they don't really apply. In Hoge, the status of being an employee is of central societal importance. Work is one of the most fundamental aspects of a person's life, providing the individual with a means of financial support and, as important, a contributory role in society. A person's employment is an essential component of his or her sense of identity, self-worth, emotional well-being. So far, I agree. But then you go on. An employment relationship is not an ordinary commercial contract, but rather a special relationship, virtually all facets of which are informed by an unequal balance of power. The terms of the employment contract rarely result from an exercise of free bargaining power in the way that the paradigm commercial exchange between two traders does. Individual employees on the whole lack both the bargaining power and the information necessary to achieve more favorable contract provisions than those offered by the employer, particularly with regard to tenure. The relation between an employer and an isolated employee or worker is typically a relation between a bearer of power and one who is not a bearer of power. In its inception, it is an act of submission. In its operation, it is a condition of subordination. I mean, those are pretty strong words, and in my respectful view, not what the reality is in the workplace. That might well be true for the hourly paid worker. It is not true for the senior executive. It is not true for the president and CEO of an organization, and it is not true for a professional employee. And with that in mind and with that background, let's turn to the case. The case is Lyons and Moltari. I only have 5 minutes, so go 7. Thank you. All right. The facts are really sort of simple. Dr. Lyons is an old oral surgeon who's been practicing oral surgery in Windsor for 25 years, finds a young, promising man, Dr. Moltari, who's just graduating from the School of Oral Surgery, and the two of them decide to hook up together in practice, with the younger doctor being an associate of Dr. Lyons. They negotiate and sign a 3-clause agreement in handwriting. Clause number 1 says how the young doctor is to be remunerated. Clause number 3 says 6 months notice of termination, both of resignation or termination. And clause number 2 says protective clause 3 YRS vertical dash 5 MI. Okay, 3 years, 5 months. Young man stays with the doctor for 17 months, gives his 6 months notice, leaves, starts a practice outside of the 5-mile radius, but 7 months into that practice, moves his office inside the 5-mile radius. Old doctor sues. Goes to trial. Dodlin J. says and his words were actually very interesting, that the covenant, the restrictive covenant, is elegant in its simplicity. In other words, anybody would know what 3 years, 5 miles means, and he does not buy the young doctor's defense, which was that he didn't understand, that the clause was too vague, and so awards damages, goes through a very nice analysis, which I don't have the time to deal with, other than to say that he concludes that there is a proprietary interest, which is essential. There is a proprietary interest that old doctor enjoys in his sources of referral. So the people who refer him oral surgery are a group of people that he is entitled to protect. And he finds that 3 years and 5 miles is not out of the ordinary. In fact, he refers to the Elsley-Collins decision, which is still one of the major decisions in Canada, Supreme Court of Canada decision, which enforced a longer term. And he awards damages. Goes up to the Court of Appeal with new counsel. Judge McPherson of Kronk fame, that lasted about 20 minutes, Judge McPherson is a very liberal gentleman, a brilliant thinker, but he comes from a very sheltered sort of background. He was a professor forever, and that's why I think it'll be interesting to ask Gouch some questions. Goes through an analysis, and he agrees that the clause is elegant in its simplicity, is enforceable from that perspective. He also agrees that a doctor has a proprietary interest in his referral base in that case. But in asking the question of whether the contract is reasonable, he says, well, hold on a second here. While the doctor, the old doctor, may well have a proprietary interest in those doctors who refer to him, he clearly cannot have an interest in those doctors who have never referred to him. Therefore, a restrictive covenant is overreaching by this doctor. The doctor can accomplish the exact same protection by having a non-solicitation clause. And by the very fact of wanting a non-competition clause, which is broader than protecting his own client base, the contract is void, and they overrule the trial decision. I guess the question that we're going to have to address, and I think over the next 2 days are going to be addressed, is that really going too far? Is there such a thing as a restrictive covenant left in Ontario? Because I can't think of very many situations, in employment situations, where you would fall into what McPherson calls the exceptional kind of case where you would need a restriction. Now, I just want to warn you that my comments should not be applied to sales of businesses, where the law is very, very different. Some fiduciary concepts, which of course are going to be covered over the next 2 days. But bottom line, in my view, and I think it's wrong, but in my view, there is no such thing as a restrictive covenant left in the employment area in Ontario after September 21, 2000. And I think all of us here are going to have to look at old contracts that we've done and send lots of lovely notices to our clients that maybe their contracts are not necessarily proper anymore, or certainly to pay attention to them from now on. And the last comment I will make is that the reason I think, with respect, that the decision is really wrong is because McPherson, in his own findings, makes a finding that these people were equals. So the whole Supreme Court of Canada coloration of employees being vulnerable, of employees not having the same bargaining power, disappears. He himself, McPherson, makes a finding that these were equal bargaining people. And I would have thought that if you have two people who are equally powerful and able to contract with one another, that they, of all people, should be held to their bargain. So that's it.
Yeah, please.
Yes. No leave has been sought to appeal. No leave has been sought as yet. Simon Zucker was the losing counsel. I called him. He hasn't been able to return my call. Ron Slatt, I don't know if Ron is here or not. Ron argued it for the plaintiff. Yes, sir. Where there is no proprietary interest? Okay. Well, for instance, you have all sorts of information in a business which isn't created by that business or specifically for that business's function in terms of how the systems work, how the accounting principles work, etc. That's clearly not proprietary. You can have all sorts of other information. We didn't get into the confidential side of my topic. There's all sorts of other information which might well be confidential, but if it's not treated by the employer as confidential, if access to it is not restricted, if it's not passed on to the employee with a clear understanding, either by conduct or expressly, that that's confidential information, it's not confidential information, and the employee is quite able to utilize that. Customers, suppliers of a business, I mean, who supply in that area, why would that be something that the employer could protect? Customers that the employee deals with are absolutely a different story. Yes, sir. One more? Sir. Oh, okay.
If there's no RC, the employee leaves, is there anything that the employee cannot do?
All sorts of things. If the employee, for instance, is a fiduciary, and a fiduciary is defined as one who has a more exacting obligation to his employer, what that person cannot do is compete unfairly. It can compete, he can compete, but not unfairly. And unfair in that situation would be using confidential information or information which came to him specifically in his capacity as a fiduciary, and using that information to his own benefit and to the detriment of the party of the previous employee. If he's not a fiduciary, as long as he doesn't take hard copy, he can do whatever the hell he wants.
Thanks, Peter. I mean, one very practical problem many of us are going to face right now in the light of the Multari case is remembering all the contracts we've drafted over the years, getting back to all of our clients, and it might be 15 years, 20 years ago, depending on how long you've been practicing, and advising them of the significance of this case. And then the more difficult part is attempting to draft new contracts that have consideration so that they'll be enforceable, that don't have the Multari problem. And that is, well, one argues in return for a raise or a bonus, but even then I find you have to say, you'll get this raise in return for this, but there can't be pressure applied to the employee to take this nominal bonus or raise. They've got to understand they're free without any repercussion, remembering the Supreme Court of Canada statements, any repercussion of any form, to not take the raise but not sign the contract. And they prefer to have an unenforceable contract to that less significant raise or bonus, particularly if they're thinking of leaving anyway. I first met Peter Thorup, about 15 or 18 years ago, when he seemed to act for most of the engineering companies. It was my plaintiff days, and I seemed to be acting for all the fired engineers. So we developed, well, after some tough slogging, some good mutual respect, to the point that we call each other. We think some of our juniors run allied from time to time over the years. Peter has become the most senior management side labor lawyer in the London area, and he's with the firm of Winkler Filion, or Filion Weekly now.
Thank you, Howard, Barry, for having me, and thank you for putting the time in to organize what looks to be a great program. I would love to poach on Paliare's topic this afternoon, but I'm going to try and, I guess, focus my remarks so I don't poach unduly on Maureen's topic a little bit later, or Chris Paliare's topic. At first, when I sort of saw my topic, I thought, is this Levitt getting back at me for that sort of rough and tumble we had 18 years ago? Drafting the hiring letter. Israel gets real law, what do I get? I thought, but then I actually, as I get older now, I do think before I shoot my mouth off sometimes, and I thought, no, actually, I might have one of the best topics, one of the most important topics, particularly to those who are starting off in their practice and do not want to sort of get fired or sued, which I think is probably all of us would prefer not to have that happen. I still do the management side, and when we were a department in a multi-service firm, and I did few of these plaintiff cases, and generally for sort of relatives, mother-in-laws, those types of things. Worst years of my life. I don't know how Howard has managed to keep his sanity, but my experience now is exclusively on the management side, and this topic, if you think about it, how many non-union employees, because in the unionized sector we have all sorts of different rules, how many of the non-union employees in the province who are hired with formal employment contracts? Versus how many are hired with a letter saying, you know, we're pleased to confirm X and Y, we look forward to you starting on this particular date, yours truly, please sign at the bottom of this letter to acknowledge your acceptance of this position. And we'll talk about the content of some of these things. And what do you think, Howard? 99%? I mean, it's the vast, vast majority of our potential clients. Or on the employer side, you're hopefully acting on a regular basis for employers. And then you say, okay, well, how do I play into all this? Now, it's easy if we're at the termination stage and it's all after the fact, and you then have the ability to sort of say to the individual or to the employer that there are these problems because certain things aren't dealt with. That isn't sort of what I want to focus on as much, because then it's just a question of some sort of uncertain litigation issues. Rather, somebody's asking you at the time, saying, well, you know, we're thinking of hiring this person, and maybe it's just as an aside, somebody, you're talking to them, and most of these letters are entirely deficient in terms of protecting or defining rights, by and large. Yet, as we know, the employment relationship is a contractual one, and this letter may be an important part of it. And you then, if you're acting for the employer, will give the advice that all of us would give, saying, well, if we really want to protect and define the rights and terms, we should have an employment contract. And now, not all contracts have to look like a mortgage document, but they do tend to be somewhat overwhelming, unless you're dealing with senior executives, and I'll talk about senior executives in a moment. But for the typical non-union employee, whether it's technical, administrative, supervisory, managerial, the employer is going to say, look, you know, there's no way I'm going to be able to use employment contracts for these hundreds and hundreds of people we hire. And so here's where I'm at on this. I mean, those are the realities. It would be nice if we could get everything nicely defined, but what's happening is I'm trying to recruit Howard, for example, to be a manager. And we've had interviews, and no, everything's fine, and he is a good candidate. He may or may not be actively employed at the time. And now I sit down and say, oh, Howard, you know, just as part of my recruitment here to try and induce you to come and move to London and work in a nice area and do all these things, I'd just like to talk about how much we're going to have to pay when we fire you later. Howard said, geez, okay. And how we really want to sort of go on the short end on the notice period and exempt you from the applicability of the bonus and the stock option if you either resign or are terminated. And I don't think Howard's going to be accepting my offer of employment. He's going to go to my competitor. So what do you do? On the other hand, Howard's there. I've given him a nice sort of letter that doesn't sort of say a whole lot, and he calls up his buddy Israel, you know, it's 8 o'clock at night, he's just got this letter. He says, I'm thinking of accepting this job, Israel. You know, can I fax over this letter to the house, and are there any problems? Now, I still get those calls, even though I'm on the management side, from, you know, that sort of large group of relatives who always want some free advice. And you know, your friends from high school and everybody else, and all of a sudden you're getting this thing and going, okay. And Howard then listens to Israel give very sound, competent advice, as he always does, and says, well, what do you mean I got to go in there and say I'd like 2 years' pay if you fire me, and, you know, you want the stock options spelled out. So it's a no-win, because, I mean, the minute Howard goes back in there and starts to then drag up what the employer is going to perceive to be new issues. So, you know, is there a way out? And on the other hand, the other problem is you say, well, you know, you've got these issues. It kind of looks okay if you're not going to have an employment contract. And then lo and behold, you know, things go south. Howard quits his job, moves down to Kitchener or London, starts in there, doesn't like the boss doesn't like him, he gets fired after 5 or 6 months, and you know, the letter said some things, and he goes to Israel saying, well, you know, now where do we go? And, or the employer says to me, well, I guess we're covered it. And the answer is, you have to ensure, particularly you know, with the employers, that they understand the deficiencies that are inherent in these. They're not useless, but the employer, in my view, is the most vulnerable to, I guess, the expectation gap on their part. If you are going to have the letters, and they will continue to be in place, then you have to think of what are the key areas. And often it's the job and ensuring, you know, what the title is and where it is and the compensation and what are the perks, what are the bonuses. And very often it's entirely appropriate to refer to other documents such as the company's bonus plan or the company's group insurance booklet and provide those to the individual, or the individual should ask to see them during the course of the interview process. But bear this in mind, and probably someone will talk about this over the course of the 2 days. I'd say the vast majority of these employer plan documents on bonuses and options and other things are themselves deficient in terms of addressing what happens when there's a resignation or termination. And if you act for employers, and particularly with that Dover decision, which you'll probably hear about over the 2 days, in terms of defining exactly the expectations and what happens if you resign or if you're terminated with respect to your profit sharing, your bonus, or your stock options. But in any event, it's a start. And the other area is conditions. You know, employers have to know that if they want somebody to come on board, but they have to pass a medical or a criminal record check, and this is all in the paper, that they have to comply with the human rights legislation, offer conditional offers of employment. Well, that has to be in it as well. The timing of the letter is critical. You wouldn't know how many times employers provide the letter after the person has sat down at their new desk. And frankly, you know, it's just a recipe for a disaster. So for both the individual and the employer, just ensure that if there's going to be a formal document or a letter, it be done up front. I had the distinct mispleasure, along with probably one of the other speakers in this panel a number of years ago, of being a situation where a senior person was being recruited. As some of these senior types go, they all have their egos. They're not going to worry about the trivia. They put the deal together, you know, over at the university club with cigars and persons there, and they say, well, we'll have the lawyers sort of get the contract over to you, and they'll work it out, you know. Well, they go in and say, well, Thorup, put in a termination provision that's sort of, you know, at the blow end. You do that. Individual comes back. Howard sort of comes up with something that's 24 months plus, and now we've got a major problem, and this is an actual case, and those were just about the exact numbers, and this senior individual has left the previous place where he'd worked, and he's now working. Now, it hasn't fallen apart yet, but what happened is that sort of dispute started the destruction of the employment relationship, and guess what? 6 months later, there's an exit. Now, the lawyers are the ones who are now caught in the middle, and their clients are going to turn to them and say, well, you know, they have short memories, and, you know, part of practicing law is protecting yourself, and because you have sort of gone along with this, and you try and say to your client, well, yeah, but I'm acting on your instructions to get this for you and get this for you, well, they soon forget that. And so you're really setting yourself up for recriminations later. And I would be very, very cautious when you get involved in one of those. I'd tell your client right up front saying, look, you know, there's a real problem here, and so that they don't blame it on you later, because in many of those cases where they're leaving it to later, it goes off the rails. And again, in keeping with the theme of not poaching on too many other people's topics, I commend the paper to you. Probationary periods. You know, employers think that they say, well, you'll be on probation for the first 3 months. And, I mean, what does that mean? It doesn't mean very much, unless you're going to put in clauses saying, Howard, during the first 3 months of your employment, you may be terminated for any reason without any notice or payment, et cetera, et cetera. Now, I mean, is Howard going to sort of gleefully join our business? And the answer is no. So your employer client is going to say, you nuts? And this is where you have to say, okay, but just know that probation is essentially meaningless. So you can't have your cake and eat it too, and you got to be very, very clear with your employer clients. Doesn't mean that, you know, you shouldn't indicate there's probation just because, you know, you want to set up a period of time where you do assess performance, but it's not going to save you money. My experience, it's generally not worth it to try and do the minutia on saying in the probation you can be terminated for X and X and X unless you're dealing with very lower level employees. Talking about that, temporary employment letters. This is where they're often poorly drafted. And they say, we're pleased to offer you the contract position of archaeologist as a result of funding available through the Israel Foundation. Great, you hire the person on, 1-year contract, the foundation is unsatisfied with the work, the funds stop, and you go to the individual and say, you know what, you've been here 4 months, and the employer says, well, you know, I looked up the Employment Standards Act, definite term or task, I don't owe you anything. Well, that's wrong under the Employment Standards Act and Regulation 327. The definite term or task allows you to avoid statutory notice if you complete the definite term or task. That's the first thing. But they say, but you know what? I'm going to give you that 1 week's pay anyway, just because, you know, we're so good-natured. And now, all of a sudden, somebody's going to come, and I imagine both these gentlemen here have won these cases, where they say, no, this isn't really about notice, Thorup. You missed the point. You know, I said, well, no, I don't miss the point. I'm trying to sort of keep this down to a manageable amount. But what it is just pay off the balance of the contract. This is a contractual matter. And you are in some jeopardy by doing that. I think I have used up my time. I thank you for having me, and I just sort of, again, warn you all, especially those who are sort of starting out, and you know, you do your client a favor and you're doing yourself, your firm a favor by sort of being very clear with your clients that these letters are only a very partial answer, and if you're going to proceed with them, you know, it's not much protection for termination. And sometimes when you get into these things, you need a way out, and you're arguing over the notice period, and you don't want to be the one to cause the executive to bolt and whatnot. One thing we did one time, and I wasn't with Peter, but we said, you know what, let's forget this, Howard. You're at 24, I'm at 12. We'll just say, look, in the event of termination, other than for cause, the employer will comply with statutory and common law. And we just sort of blew the whole issue away, which we probably shouldn't have raised in the first place. And that managed to salvage it. The executive went on, and life was grand. Thank you very much.
Thanks very much, Peter. And the point as well is especially well taken in the era of perhaps we're going to be moving to full employment, if the demographers are right. And so how do you, in that hiring letter, not, as Mr. Justice Gans say, piss somebody off and then send them to the competitor? That's the most complex thing. It was fine in the mid-90s when employment was at a different level. But today, there's a significant competition, and that hiring letter is going to be very vital, and your clients are going to be looking to you to draft it so that you don't scare away clients.
And there's no happier client than that which tells you that they're reading about wrongful dismissal cases every day in the newspaper, but because of the contract or letter you drafted for them, they've never had a problem. We're going to take a break now. If we can be back at 11:05, we're going to catch up with most of the lost time.